You think this is a game, Ms. Okafor? The voice belonged to Regional Director Arthur Blythe, and it sliced through the conference room like a blade. You walked into my hospital, you questioned my staff, and now you're sitting here telling me that I owe you, a ward clerk. An explanation? He straightened his cuffs. He smiled. It was the kind of smile that had ended careers. Security will see you out. Amara Okafor didn't move. She was 23 years old, 5'4", and she was wearing a blazer she'd bought second-hand from a Goodwill on Cottage Grove because she couldn't afford the kind that came pressed and new. Her mother, Josephine Okafor, was in room 412 of Mercy Regional Medical Center, attached to a ventilator, brain damaged from a medication error that the hospital's legal team had already begun quietly burying. And Arthur Blythe, the man who ran this institution, the man who lunched with aldermen and donated wings to buildings, and appeared at ribbon cuttings in a hard hat and a smile, was looking at Amara like she was something he'd scraped off the bottom of his Italian leather shoe. They thought she would cry. They thought she would apologize and leave. They had no idea she had already found the document that was going to take the whole thing down. Josephine Okafor had worked as a home health aide for 26 years. She had strong hands and a soft voice, and she knew exactly 3 things about medication. You took what the doctor said, you took it when they said it, and you didn't miss doses. She had gone into Mercy Regional on a Tuesday in February for what was supposed to be a routine gallbladder removal. Standard laparoscopic procedure. The surgeon had done it 400 times. Josephine had packed a bag with 2 days' worth of clothes and a bottle of her sister's homemade pepper soup in a thermos because she didn't trust hospital food. She never came home. The surgical team had administered the correct anesthesia. The procedure had gone smoothly. But in the post-op recovery room, a nurse named Candace Holt had administered a dose of a blood thinner, heparin, at a concentration 10 times higher than what was prescribed. The error went unnoticed for 40 minutes. By the time an attending physician caught it, Josephine had suffered a catastrophic hemorrhagic stroke. She was alive, but the woman who had packed that bag, who made pepper soup from scratch and called Amara every Sunday morning at 8 a.m. without fail, that woman was gone. Amara had been at work when it happened. She was a ward clerk at St. Augustine's, a smaller hospital on the south side, which meant she spent her days filing intake forms, flagging insurance discrepancies, and routing requests from nurses who were always too busy and doctors who were always too important to look up from their charts. She wasn't a nurse. She wasn't a doctor. She had a 2-year associate's degree and 12 hours of medical billing certification. She knew better than most people on the street how a hospital worked, its rhythms, its paperwork, its silences. She knew what it meant when a chart got amended. She knew what it meant when a supervisor's name suddenly appeared on a form it hadn't been on before. She knew what it meant when a family was called into a room with a hospital attorney, before they'd even been called in with a doctor. That had happened on day 3. A woman named Patricia Holloway from the hospital's risk management office had sat across from Amara and her aunt, Cynthia, and expressed deep, rehearsed condolences. She had slid a document across the table. It was a settlement offer, $240,000, a waiver of all liability, and a non-disclosure agreement with a clause so broad it covered any and all communications, oral or written, regarding the events of February 14th and their aftermath. They wanted Amara to sign before she'd seen the incident report. She didn't sign. The next 4 months were a kind of warfare Amara hadn't been trained for. She hired an attorney, a medical malpractice lawyer named Douglas Ferris, who had a decent reputation on Yelp, and an office above a dry cleaner on 79th Street. Ferris was a good man with an overwhelming caseload and a tendency to take the settlement rather than the trial. He filed the initial paperwork. He sent the formal request for Josephine's complete medical records. Mercy Regional's legal team, a firm called Galton, Rowe, and Ashworth, 300 attorneys strong, with a satellite office in 4 states, responded with 17,000 pages of documents in a format that required specialized medical records software to read properly. It's a common tactic. Ferris told Amara over the phone, his voice tired. They drown you. Most families give up. The software license alone is $1,200. Amara did not give up. She filed a complaint with the Illinois Department of Financial and Professional Regulation. They acknowledged receipt. They said the review process could take 12 to 18 months. She filed with the Illinois Health Facilities and Services Review Board. They sent a letter that was so full of procedural language, it took her 2 evenings to pass. She filed a detailed complaint with the Joint Commission, the national body that accredits hospitals. They opened a preliminary inquiry. Mercy Regional's PR department issued a statement about their ongoing commitment to patient safety and continuous quality improvement. Nothing moved. Meanwhile, Josephine was in a long-term care facility in Calumet City, and the cost was $8,400 a month, and the frozen settlement offer, which Amara had refused, was the only money on the table. And Amara was working double shifts and sleeping 4 hours a night and eating whatever was left in the break room at St. Augustine's. Arthur Blythe gave an interview to the Chicago Tribune about Mercy Regional's new patient safety initiative. There was a photo of him at a podium with the mayor. He was smiling the same smile he would later give Amara in that conference room. She had requested the meeting through official channels. She had been granted 15 minutes. She had brought a single folder. When Blythe smiled her out of the room, she stood up slowly, picked up the folder, and said 4 words, "I'll see you Tuesday." He laughed. She left. What Arthur Blythe didn't know, what none of them knew, was that Amara hadn't asked for the meeting to negotiate. She had asked for it to confirm one specific thing, and she had confirmed it. It had started 6 weeks earlier, in the way that catastrophic discoveries often start. With boredom and insomnia at 2 in the morning, Amara had been cross-referencing the incident report. The version Mercy Regional had finally released, heavily redacted, against the nursing shift schedule that Ferris had managed to obtain through a narrow records request. Something didn't match. The incident report listed Nurse Holt as the administering nurse. The shift schedule showed Holt had clocked out at 2:47 p.m. The heparin administration, per the same incident report, had occurred at 3:12 p.m. 25 minutes after Holt had left the building. Amara stared at that for a long time. Then she went back through the 17,000 pages. She was a ward clerk. She knew how medical records were structured. She knew where the signatures lived and what the timestamped fields meant, and which fields were auto-populated by the system versus manually entered. It took her 11 days and a borrowed login to a medical records database, obtained legally through St. Augustine's professional access that she'd never thought to use before, to understand what she was looking at. The incident report had been amended, not once, 3 times. The original version, filed at 4:18 p.m. on February 14th by the floor charge nurse, listed the administering nurse as T. Brunson. The second version, filed at 9:52 a.m. on February 15th, 19 hours later, changed the name to Candace Holt. The third version, which was what Mercy Regional had provided to the family, was the one with the redactions, T. Brunson. Amara looked up every nurse with the initial T and last name Brunson who had ever been employed at Mercy Regional. There was one, Tanya Brunson, RN, who had worked in post-op for 11 years and had resigned. The HR system listed her departure as voluntary 4 weeks after Josephine's stroke. Amara found Tanya Brunson on LinkedIn. She was now working at a clinic in Naperville. She had not posted in 8 months. Her most recent activity was a share of a prayer chain for healthcare workers. Amara sent her a message. It took 3 weeks and 2 follow-ups, but Tanya Brunson finally called. She was crying before she finished her first sentence. Tanya had been the one who administered the heparin. She had administered it exactly as the medication order appeared in the system, except the medication order in the system had been wrong, entered by an attending physician named Dr. Raymond Voss at a dosage that was a decimal point off, a catastrophic error that Voss had recognized within the hour. What happened next was what Amara had suspected and could now prove. Voss had gone to his supervisor. His supervisor had gone to risk management. Risk management had gone to legal. And someone, Amara could not yet prove who, though she had a strong suspicion, had gone into the electronic health record system and amended the medication order retroactively, changing the timestamp, making it look as though the order had always read the correct dosage. The error, on paper, disappeared. What remained was a nurse who had administered a drug outside of the standing order, an order that, in the system, no longer matched what Tanya Brunson had actually seen and followed. Tanya had been told, quietly, by her nursing supervisor, that the hospital was prepared to report her to the Illinois Department of Professional Regulation for medication administration error, which would end her nursing license, unless she resigned voluntarily and signed a separation agreement that included a non-disclosure clause. She had signed. She had been 28 years old, with student loans and a daughter in first grade, and she had signed. Tanya gave Amara one thing before she got off the phone, her voice barely above a whisper. "I kept a copy of the original order," she said. "I printed it that day because I knew something felt wrong. I've had it in my closet for 4 months. I didn't know what to do with it." Amara knew exactly what to do with it. She went back to Douglas Ferris. She laid out everything. The amended incident report in 3 versions, the shift schedule discrepancy, Tanya Brunson's testimony, and the printed medication order, a physical document with a timestamp that predated the system amendment by 3 hours and 40 minutes, showing a dosage that had since been scrubbed from the official record. Ferris went quiet for a long time. "Amara," he finally said, "this isn't a malpractice case anymore, I know. If what you're saying is accurate, the alteration of medical records is a felony under Illinois law. The retaliation against the nurse is a separate violation, and if risk management directed the falsification, we're looking at institutional fraud. I know, I need to be honest with you. A case like this, against a hospital system this size, they will come after you. They will come after the nurse. They will try to discredit every piece of this. I know that too." Ferris stared at the folder on his desk. Then he picked up his phone and called a colleague who specialized in whistleblower litigation. The deposition of Arthur Blythe was scheduled for a Tuesday in August, in a conference room at the Cook County Courthouse. Amara arrived 30 minutes early. She was wearing the same second-hand blazer. She had ironed it the night before with the iron she kept under her bed in the apartment she shared with her cousin on the East Side. She had not slept. She had spent the night going over every document, every timestamp, every thread of the case that she had built page by page over 5 months of insomnia and fury and love for a woman who used to call her every Sunday. At 8 a.m. Blythe walked in with 4 attorneys. He was wearing a suit that cost more than Amara's monthly rent. He looked at her the way he had looked at her in the conference room, like she was an inconvenience that would soon be resolved. His lead attorney, a man named Preston Galton, opened the session with a statement about Mercy Regional's full cooperation with the process and their deep compassion for the Okafor family. He said the word compassion 4 times in 3 minutes. He had the cadence of a man who had said these things so many times that he no longer heard the words. Douglas Ferris began with the standard questions: employment tenure, administrative responsibilities, familiarity with hospital protocols. Blythe answered everything smoothly, occasionally glancing at Galton, who occasionally nodded. Then Ferris handed Blythe a document. "Mr. Blythe, I'm showing you what's been marked as Plaintiff's Exhibit 31. Can you tell me what this is?" Blythe looked at it briefly. "It appears to be an internal incident report. And who would have authorized changes to an incident report after initial filing? The charge nurse or supervising physician, with appropriate clinical justification. Is it standard procedure for risk management to be involved in amendments to clinical incident reports? Risk management supports our documentation processes. Yes. Is it standard procedure for risk management to be involved before the family of the affected patient has been notified of the incident?" A half-beat pause. Galton started to object. Ferris acknowledged the objection and moved on. Then Amara leaned forward. Ferris had agreed, after considerable discussion, to allow Amara to submit written questions to be read into the record. It was unusual. It was permitted. Ferris read them aloud. "Mr. Blythe, are you aware of the existence of a medication order for Josephine Okafor that differs from the version currently present in the electronic health record?" "I am not aware of any discrepancy in the medical records. Are you aware that the original incident report, filed at 4:18 p.m. on February 14th, listed a different nurse as the administering clinician than the version provided to the plaintiff's family?" Galton objected. Ferris noted the objection for the record and continued. "Mr. Blythe, let the record reflect that the witness has stated he is not aware of any discrepancy in the medical records." He then slid Exhibit 47 across the table. It was the printed medication order. Timestamp, dosage, the name of the ordering physician, unaltered. Predating the amended electronic record by 3 hours and 40 minutes, Blythe stared at it. Galton put his hand on Blythe's arm. Ferris continued, his voice perfectly level. "Exhibit 48, Mr. Blythe. This is an email chain between your Director of Risk Management and your Chief Medical Officer, dated February 15th, obtained through the electronic discovery process your team provided. I'll direct your attention to the third message in the chain, timestamped 8:44 a.m., in which your Director of Risk Management writes, and I'm reading directly. The order entry has been corrected in the system. Nursing is being handled separately. Voss is aware. We need the family paperwork moving by Thursday. The room went very still. The order entry has been corrected in the system. Ferris repeated quietly. Mr. Blythe, is that consistent with your statement that you are not aware of any discrepancy in the medical records? Arthur Blythe, for the first time in what was probably a very long time, had nothing to say. The Illinois Attorney General's office opened an investigation within 6 weeks of the deposition transcript being filed with the court. Galton, Rowe and Ashworth withdrew from the case 2 weeks after that. The Director of Risk Management, a woman named Sheila Vance, cooperated with investigators in exchange for reduced charges. Dr. Raymond Voss lost his clinical privileges pending review. Arthur Blythe was indicted on 2 counts of obstruction and 1 count of conspiracy to falsify medical records, a felony, under Illinois Statute 720 ILCS 517-3. Candace Holt, who had been quietly carrying the weight of an error she hadn't made, was fully exonerated. The hospital's own investigation, forced by the AG's office, confirmed she had administered the drug as ordered. Tanya Brunson's nursing license was reinstated. She went back to work. The case, Okafor v. Mercy Regional Medical Center, was settled for an amount that covered Josephine's care for the rest of her life, with enough remaining to fund the education of every child in the Okafor family for the next generation. The settlement included no non-disclosure clause. Amara had insisted on that specifically. A provision in the settlement required Mercy Regional to implement an independent third-party audit of all incident report amendments going forward, a process that, once codified, became the basis for a new Illinois Health Department regulation governing electronic medical record integrity at all state-licensed facilities. Amara Okafor had walked into that conference room as a ward clerk in a second-hand blazer. She walked out as the reason hospitals across Illinois would never again be able to quietly erase a mistake and leave a family to grieve alone, wondering what had gone wrong. She went to see her mother the afternoon the settlement was signed. Josephine was sitting up in her chair by the window, the way she always was in the afternoons. She couldn't speak. She didn't always recognize Amara's face. But when Amara sat beside her and took her calloused hand and said, "It's okay, Mama. I took care of it. We're okay," Josephine turned her head slowly and looked at her daughter, and she squeezed her hand back. The system had counted on Amara being too young, too small, too unknown, too exhausted to fight. It had counted on 17,000 pages being enough to drown her. It had counted on her signing on the dotted line and going away quietly. It had miscalculated. The truth does not care how powerful the person trying to bury it is. It only cares how stubborn the person trying to find it is. And Amara Okafor, daughter of Josephine, ward clerk, 23 years old, was the most stubborn person in any room she had ever entered. She always had been.